Hello and welcome. This video, Some Guidance for More Complex Estate Plans, is number 9 in a series of 10 videos designed to educate Utah residents about estate planning. For a list of all of our videos, see below or return to our website. In this video, we will identify several points that you should discuss with your estate planning attorney if you have a sophisticated estate plan. For more detailed information, you can visit our website at utahtrustsandestates.com. Attorneys sometimes suggest estate planning techniques to clients that appear simple from the attorney's perspective, but end up being unwieldy from the client's perspective. In general, before the estate planning client agrees to a course of action, she should ask the attorney, what additional bank or brokerage accounts will need to be opened and maintained? What additional income tax returns and/or gift tax returns will be required each year? What restrictions will exist on the client's ability to access funds? What real estate appraisals or business valuations will be needed on a regular basis? And what continuing attorney involvement will be needed? It is often the client's accountant who will bear the burden of a sophisticated estate plan. Accordingly, another important question for the client to consider is whether her accountant is sufficiently familiar with the type of estate planning transaction contemplated. For example, if the attorney recommends a sale of partnership interests to an intentionally defective grantor trust, does the client's accountant have experience with such arrangements? One final note on complexity. Estate planning professionals are not infallible. The more complicated an estate plan is, the more likely it is that something will go wrong. It never hurts to ask the attorney if there is a more simple way to accomplish the same result. An attorney may recommend an estate planning technique to a client because it will save estate taxes, but fail to explain to the client other tax consequences. The client should always ask the attorney to explain to her each of the following tax ramifications of adopting a particular estate planning strategy: income tax consequences, capital gain tax consequences, estate tax consequences, gift tax consequences, and, depending on what state you are in, property tax consequences. It is also helpful to ask the attorney what the tax consequences will be under different market scenarios. What will happen if the value of the property dramatically appreciates? And what will happen if the property declines in value? An estate planning client should always be clear about what services the attorney's fee includes and what services it does not include. Will there be an additional charge for obtaining a tax identification number for an irrevocable trust or a partnership? Preparation of gift tax returns, preparation of deeds, assignment of partnership interests to the trust, preparation of life insurance policy endorsements, coordination with real estate appraisers, or phone calls to answer questions that the client may have in the future. When an attorney quotes a fee to the client for the legal work associated with a sophisticated estate planning technique, such as a family limited partnership, the client should always ask what additional fees, such as real estate appraisals, business valuations, and state filing fees, will be needed to implement the technique. The client should also ascertain what ongoing fees will be needed, such as annual state registration fees and annual accountant fees, to prepare additional income tax returns. Clients often assume that a particular estate planning technique can be unwound if it does not turn out the way the client anticipated. While some entities, like limited liability companies and limited partnerships, can be dissolved, other entities, like irrevocable trusts, often cannot. Similarly, once a gift has been completed, it usually cannot be revoked. Unanticipated circumstances frequently arise after the client completes an estate planning transaction. Before completing a transaction, the client should always ask the attorney whether and to what extent it will be irrevocable. Once the estate plan is implemented, it may fall to the client to keep it operational. For example, if the client has an irrevocable life insurance trust, certain procedures will be required to ensure that the desired tax results will be realized. For example, annual insurance premiums must be paid from certain funds and not other funds, and notices must be sent to beneficiaries each year. Whatever advanced estate planning technique the client has adopted, the client should ask the attorney to provide her with a list of items for which the client is responsible, including gift tax returns that will need to be filed, income tax returns that will need to be filed, state registration fees that will need to be paid, and notices that will need to be sent to beneficiaries. That concludes this video. I hope you have found it helpful. For more information on this topic, you can visit our website at utahtrustandestates.com or call us at the number you see on your screen. If you would like to watch another video in this series, either click on the appropriate link below or return to our website. Thank you.